Hello and welcome to another segment of Good to Know Family Law Topics. Today I'm going to talk to you about what it takes to get an exclusion of the family residence. In other words, how do you get the court to exclude the other party from being in the family residence during your divorce? We call these orders kick-out orders, and they're not as easy to get as you might think. Now, before I tell you the three things that you're going to need to get an ex parte restraining order, let me start off by telling you that it's not uncommon for people to continue living together during the pendency of their divorce. After all, sometimes it makes sense. It's expensive to live in two different households during divorce, and people sometimes, even though they don't like each other, they're able to live together peacefully. On the other hand, there's a lot of occasions where people cannot live together any longer because of the high degree of volatility within the household. In that case, one or both parties are going to ask the court to exclude the other from the family residence. Now let's talk about the three things that a person needs to show the court before the court's going to issue such an order on an ex parte basis. And when I'm talking about an ex parte basis, I'm talking about an expedited order, an order that you could get within 24 hours of giving the other side notice. The first thing that a party is going to have to show is that he or she has a colorable right to the premises. In other words, you have a legal right to occupy that premise. It doesn't mean that you have to be on title, but it usually means that it's your residence. Let me give you an example. Let's assume that it's a husband and wife, and the house is titled under the husband's name. Wife's not on title. It doesn't matter. The wife has a colorable right. On the other hand, boyfriend and girlfriend, they don't live together. Girlfriend's merely visiting boyfriend at his apartment. Well, in that case, the court might not think that she has a colorable right to have exclusive use of those premises. The second thing that has to be proven to exclude a person from the family residence is to show that the person to be excluded has either threatened or has assaulted the petitioning party or somebody that the petitioning party is caretaking, like a child or a family member that lives within the residence. You can't just go into court and say, we're not getting along, or we're arguing a lot. That's not enough to make it if you're trying to get an ex parte order excluding a person from the family residence. The third thing that must be shown is that if the court does not exclude the other party, that there's a likelihood of emotional harm or physical harm as a result. Now let's assume that you cannot make the showing of all three factors. Don't give up, because there's still an opportunity to exclude the other party if you can file a notice motion and get into court within the regularly scheduled time, and you could show that if that person's not excluded, that there's likely to be emotional harm caused by that person still being in the residence. And in thinking of that type of a situation, think about people who are yelling and screaming in the presence of children constantly, arguing. Now, there's no assault, there's no threat of assault, but that high degree of volatility is likely to cause emotional harm to the children. And as you can see, as I'm talking, that when there's children in the household and there's a lot of volatility, there's more likelihood of getting an exclusion order. Now, as a final tip, let me suggest that if you can't get an exclusion order, there are some alternatives. One of them is move out of the family residence. The second is perhaps you could get the house sold during the pendency of the divorce and thereby freeing up some money. And the third one is what we call bird nesting. And that's where the parties share the residence alternatively. For example, week on, week off, father and mother come to the family residence and the children stay in the residence during the pendency of the divorce. Now, the bird nesting option is not a long-term fix. Our experience shows that it doesn't really work after the divorce, but sometimes it works during the pendency of the divorce in order to keep the children stable. And that's all I have for this topic today. Thank you very much for joining us on Good to Know Family Law Topics. Be sure to read our blog to learn more about very important family law topics that may help you in your case.